I think the talk is working. Right? Your Excellency, distinguished colleagues, it is a very great pleasure to be here, and I would like to thank the Pontifical Academy of Social Sciences and Margaret Archer for this wonderful opportunity to come and talk to you this afternoon. I think it is a defining moment, is it not, that the act that I'm about to talk about has just become law a few weeks ago. And I'm confident that this is its first outing. And I think it's appropriate that it should be in the Vatican. We in Britain have been celebrating Magna Carta, that great charter of rights, of obligations, of what the sister just explained, human dignity. Yet it was not what it seemed to be. The charter came from the decision by the then King of England to reject the advice of Pope Innocent II. Perhaps Pope Francis will learn that rejection, it does not mean ultimate loss of dignity, because the story goes thus. Undaunted, the Pope persisted. He wanted the correct man to be appointed the Archbishop of Canterbury. The King demurred eventually. And then there was what we call a constitutional crisis, precipitated by the issues that we are discussing this afternoon. Who is entitled to discuss human dignity? If not the King of England, then the Pope of Rome. Between the two, the Pope got it right and the King got it wrong. The King got it wrong because what he was dealing with was a feudal system where one voice did not count with equality. It was, if you like, the early example of the deficiencies in law at that time in England. And the Magna Carta then came into being. A lot of claims were made about it. It is said it established jury trial. It did not. It was said that it would produce a new rule of law order. It did not. In fact, it is a guide to how we interpret legislation, which is the theme of my discussion this afternoon. If you read the detail of the legislation in the technical sense of line by line, full stop by comma, you will probably think that the Charter did all the things it is claimed of it. Yet in fact it lasted for a very small amount of time, but the effect culturally on the people of Britain changed forever the direction of the common law, because it defined it as law, not the whim of the king. And the Pope won his day ecclesiastically, spiritually, and every other way, because it meant that there was a better settlement in England, and as a result of that, a legislation should be interpreted. Forgive me for starting out with these general observations, but I think they're pertinent. In the room around us are many different cultures and countries. Some share our common law tradition of England, of Anglo-Saxon law, many do not. I think it's important for you to remember that in our common law system, we do not have the experience of judges making laws or holding them to be illegal or unconstitutional, but for the few examples to do with the EU law and perhaps when it comes to dispute over human rights and the Strasbourg Court. But that is contentious. The point I make then is that our legislation is the result of a unique process because its authority carries with it the undiminished sovereignty of our Parliament. And therefore, when you read the legislation, you have to be very careful that you understand exactly what it is it does. And my mission this afternoon is to do a number of things. First, to describe the architecture of the Modern Slavery Act, then to go through the context for which it was built and why it was passed and the way it was. I should say that I owe a great debt to Kevin Hyland, who yesterday did a marvelous job, a really excellent presentation of some of the details of the legislation. And as the independent anti-slavery commissioner, he really got the essence of it. So I would feel very honored to follow him today and to give you an analysis of the legislation which I think should take you into the point of how you interpret it and how it may be taken forward. So the politics of legislation in England matter, because rarely do many countries allow the political whim, or if you like, choices, to prevail so abundantly. This is a Home Office bill, and if it had been drafted by a different department of government, it may have resulted in something different. The point I make is this: the abiding, if you like, obsession or the political dynamics shared by many in this room, but certainly shared personally by the Home Secretary, to which we should give her great respect for continuing with the Act and making it possible for it to be passed, was that the criminal law had a fundamental part. So in that respect, the Act does something specific. It is a work of consolidation. In other words, it sets out offences that have been defined in this legislation in a way that had not been done precisely before. Section 1, slavery, servitude, and forced or compulsory labour, and Section 2, human trafficking. Two separate offences, but interconnected in different ways. And that consolidation is then taken forward in the legislation through different elements of it in terms of a bundle of criminal law-related attempts to regulate, if you like, through the criminal law, the process of criminalization of these serious offenses. It rests on public opinion. It rests on the notion that victims are best protected through the medium of the criminal law. It also rests on a long historic tradition where we look at criminal sanctions in terms of command and control. And I, for one, would not wish to dispute that. It is clear to me that that part of the Act and its assortment of regulatory operations dealing with tracing money and finding all sorts of ways of unlocking the profits from this illicit and illegal operation are then bolted together in a way which will be interpreted by courts, we hope, in a way that will encourage the prosecution authorities to engage and set out cases that will lead to successful prosecutions, that will act both as a deterrence, as a prevention, and ultimately to provide sanctions. But as I say in my paper, and I'm not speaking by reading the paper, I'm speaking to the paper, I do believe that there's another dimension, and that dimension is found in another part of the legislation which goes along with the consolidation of the criminal law, but which I would describe generally as enabling. Why do I use the term? Well, simply it is a work in progress. That is to say, it creates avenues of regulatory behavior which potentially can lead on to what the sister just said a few minutes ago, a recognition that legislation itself does not solve problems, but may lead to different solutions. Let's be clear. When Magna Carta came into existence, there was a great deal of noise, a great deal of what you might call diaspora of thinking, that it was our moment constitutionally. I want to ask, do we have the same moment here? A few weeks ago, the Home Secretary wrote the following: "We have passed the law, now let's crush slavery." Now, we can be cynical, and we can be concerned that criminal legislation of this kind will produce that outcome. But let us not in any way dilute the message. The message sends a clear signal that there is a seriousness of purpose and a bundle of legal rules that, if applied, and in the past we know it has not yet been successfully applied in terms of the numbers of prosecution. One of the themes that comes out of many of the discussion papers yesterday and today has been the difficulty, quantitatively and qualitatively, of getting together sufficient evidence, providing the necessary arrangements to bring criminal acts into the criminal law and penalizing them. So there are a lot of reasons for optimism that the new Act, with its two elements, a section on slavery which deals with when one knows or ought to know that the other person is held in slavery, and where all the circumstances will be looked at, and not just the intention of a person, but the whole elements of what took place, that along with human trafficking, which relates to the facility of travel, and then a related set of conditions relating to exploitation, and this goes to sexual exploitation, slavery itself, removal of organs, and securing services by force or threat. And the optimism is that we will then lead to a template of standards which has been set by the criminal law, which would also mean that it might be possible to go forward with other regulatory mechanisms. Just one point to make is that we have had some experience of looking at alternatives to criminal law in terms of the gangmaster's licensing authority. This legislation, which Cardinal Nichols and I think the Pope were very much engaged in promoting, and it is to their credit that it became law in pretty short fashion in 2004, and it dealt with employment standards, and it dealt with the whole question of trying to produce some solution to the economics, which are at the heart of some of the motives behind people who engage in these awful acts. I, for one, would have liked better knowledge about how that Gangmasters Act had operated before legislation had perhaps been put before Parliament, more evidence about that and so on. To the Modern Slavery Act, let me say this. The Act has some lessons for us in terms of the model of how legislation is passed. As you probably know, we have a system of 3 readings in each House of Commons and Lords. But this bill attracted a very important innovation, relatively new. The innovation is a pre-legislative scrutiny, and Kevin Hyland highlighted this point yesterday in his discussion, and he was quite right to do so. Because in the political polemics and the noise of party disputes and conflicts, and indeed the debate about whether it is criminal or not criminal, or whether the criminal law will work, there is often a polity that takes away from the expertise that is around this room. And I think it is to the credit of the system that under the safe and very strong leadership of Frank Field, a Member of Parliament, he managed to get both Houses of Parliament to collect evidence, to take information, to take the analysis beyond the party politics of the day and incorporate a good discussion that, in a sense, brought us into a better position than if the bill had simply been drafted alone by the Home Office on its own recognizance. So that is to his credit. I've only touched briefly on the criminal law because I interpreted my remit to issues beyond criminalization. I took that quite seriously. And on page 8 of my paper, I begin to discuss the Independent Anti-Slavery Commissioner. My comments are not ad hominem to the excellent work that I have no doubt Kevin Hyland, the first commissioner, will do, but generic to the post, and also to do with the question of how this post may later develop. I have a number of thoughts. The first point is that the connection between the politics of public opinion, which everyone around the room recognizes, is at the essence of persuading governments and leaders of international organizations of the agenda setting that is so needed. And that is part of the publicity of what we might call accountability. Not accountability so much as it's misunderstood of the actions of the commissioner, but accountability of what it is that human trafficking is and at how it is being regulated. And it seems to me this is a voice in terms of the annual report to Parliament, oversight by select committees. I honestly think that what should be pushed for the next Parliament is a designated select committee of the House of Commons, but preferably the House of Lords, the Anti-Slavery Committee. There should be no negotiation on it, because it should be there not just to hear from the excellent work I have no doubt that Kevin Hyland will do, but of the problems he faces. and of the need to recognize this enabling legislation is what it is. It is there to enable, but not as a static moment in time. What strikes me is that the evidence about human trafficking and slavery is a reflection of the global diaspora of conflict, of social distress, and the changing economic circumstances of many countries. That is not fixed in time or predictable in future. But what it is a moving and often predictable outcome of risk. And I think we need to know up front where we stand, to have proposals, to have scrutiny, and to take forward to the next step. There are a wide variety of economic possibilities that a commissioner in the future may be given, including, if necessary, taking forward a proactive step of imposing some degree of sanctions in terms of economic sanctions on companies that do not provide information, rather than reacting to the exigencies of what is given in information itself. I'm reminded of the depression that many people felt when we first introduced an ombudsman system in the United Kingdom in 1967. Let me just recall to you the prophets of doom. It wasn't an ombudsman we were getting, but an ombudsmouse. He had no powers. He had no statutory duties. Why, they did not even define maladministration. And yet, from that time to now, we have real proactive encouragement of cases being taken and being settled, of arbitrations being reached, compensation given, and public opinion being recognized for what it is, a voice in the integrity of human beings and in the possibility of encouraging a cultural shift in our attitudes to why it is we tolerate in everything we do, in every life we have, the commercial impediment to buy and to sell the bottle or the goods or the services without questioning its integrity. On this bottle, we can find all the information about how good it is, the quality of the water, but there's nothing that says it has not been produced by human slavery or trafficking. There's nothing that suggests that the human element in this production is there, and yet it is so necessary. So why have we not got, if we do value this subject, a kite mark which says this bottle or this T-shirt has not been as a result of exploitation of human trafficking? It is non-negotiable. We accept the need for environmental standards, ISO. We accept the need for pure water. Why do we not accept the dignity of human beings in the production of the products? This brings me on page 9 to the other achievement which I think the bill has done. It is a rather complicated problem. The victim is very much often involved in the offense. Not because the victim is willing, but because as a victim they are implicated in the criminal activity. I cite an important case where the attempts by the courts to give some direction to our prosecution authorities give you an indication of how difficult it is to both define the victim, but also to provide the kind of information that is reliable for prosecutors to create a standard, so the victim is not inadvertently penalized or, worse, criminalized. Kevin Hyland will know very well that this can be difficult, both for the prosecution and the police. I often think the police are on the front line and often get dumped more and more of these responsibilities without either the resources or the advice needed. You can read this for yourself. They are legal questions, are they not? Difficult to answer. And remember, many of these victims will not have necessarily the knowledge, the recognition of their plight, let alone the legal advice needed to determine their position. Yet, social workers, many religious groups will know only too well of who they are, what they are into, and how difficult it is for them to come to terms with a society which is often authoritarian because of the institutions that are there, to ensure that citizens have rights and obligations, but equally that they are protected. It must look a rather scary moment to have to confront the fact that as a victim you do not necessarily have a voice. I think the Slavery Act has gone a long way to provide a statutory defence. It remains to be seen how that will work in practice, but it is a start. And it certainly allows legal advice to be given at the right time, and related to that are the independent child trafficking advocates, which I feel is a very good step in giving a voice to vulnerable children in particular, to ensure that their best interests under Section 48 of the Act are protected, and that regulations will then give us advice as to how these protections may take place. I just might add a slight disappointment. My own personal view is that the Act missed an opportunity, perhaps, to define more clearly the presumption on which it should operate. I recall the struggle to get into one of the Children Acts in the United Kingdom, that important test that the welfare and interests of the child are paramount. And my argument is that the welfare and interests of the victim ought to be paramount. Now, it is difficult to put perhaps that test into legal terms, but the essence of it is there in the spirit of the legislation, if not in the drafting of the actual section. I now turn on page 12 to the plight of overseas domestic workers. This is but one category of many which is clearly identified as one of the vulnerable groups upon which, susceptible to exploitation, there is mounting evidence that they are the victim of these heinous offences. We know the government is taking this seriously because the legislation allowed some laxity in our existing system, whereby the visa arrangements of one employer could be transferred to another in the exigency of someone who had complained that they were in fact being trafficked or indeed in some way subject to bad treatment. This is a good example of the best of practice, I think, namely that it was not easy to get concession. There was general discussion. There was a ping-pong between the House of Lords and the House of Commons. It went right to the wire at the end, and I'm glad to say that I think Section 53 has now been taken forward in legislation through the amendment to visa conditions, which has now been brought into operation, just literally a few weeks ago. So this is an example, I think, of a model of an area where the barriers to success have always been there. It's one identified area, overseas domestic workers. It's fairly defined, and therefore the traffic itself is very well known and, you might say, very visible. But I would strenuously argue that this is an area perhaps for expansion of the same kind of idea and the same system to apply to other areas of other activities. Now, I recognize the authorities may be reluctant. The point about overseas domestic workers is that they usually have some degree of permanence of residence. In other areas, particularly agriculture and the related employment in different parts of the industry, building and so on, it may be less easy to track down people. And it's a fair point that tracking them down and ensuring that they are, as it were, protected is as important as knowing that they exist. But I do believe that a start has been made, and I think, as you can see in my discussion, after a number of attempts, I think we've moved in the right direction. There are a number of related powers relating to prevention orders and enforcement powers relating to ships and so on. All of these are necessary, and you may read for yourself in the Act. I come to the last, but perhaps the most interesting and most important. The corporate supply chain is really to do with something which, to date in the conference, we have discussed around, but not necessarily discussed fully. It is the case that many of us come from institutions, public or indeed private, but at the heart of it is the economic fact that none of these practices would be possible were it not that a lot of people make money and a lot of people in the supply chain are difficult to track down. There are clever lawyers and accountants and businesses, multinational and otherwise, who can hide the facts. Let's be clear, money laundering is not new. Mafia-style crimes are common. I reflect on this fact that for many years we have tried to regulate our financial services with moderate effect in terms of the 2008 financial crisis. So it is fair that a start has been made in the legislation by requiring quoted companies to report on the impact of their supply chain in terms of the social, economic, and human rights issues concerned with slavery. It is a rather weak section if you test it to the bit of the consolidation I talk about to be found in the criminal law. If you compare the two, you can see that it's quite clear that this is by no means sanctioned by criminal sanctions. It's a reporting obligation. It is, if you like, good progress in terms of due good practice. It's encouraging people to behave transparently and so on. But perhaps this is something that the Anti-Slavery Commissioner may do, to monitor, report, to think about how this area may be taken forward in the future, and maybe building the blocks that are needed to get the commercial organizations to take responsibility, a kind of corporate social responsibility for these particular areas. My guess is that in terms of the sellability of this idea, it should come high. After all, free trade and the ability to relate to free trade is an important selling point, especially if you can show that the product has the quality of not being trafficked or part of slavery. That goes back to the moral dynamics of which I speak. Sadly, the Act says little about repatriation in international law, a vitally important topic, but it does not really deal with this. Yet it is something that I think may be the subject of another Act of Parliament, or indeed another attempt at the issue of providing people who simply cannot go to another country through repatriation, need to be given, as Professor Archer outlined this morning, the right to abode and may even ultimately the passport that's needed to respect their dignity. I accept that that is a work in progress, but if we're looking at locating this discussion in the sustainable development discussion of Jeffrey Sachs this morning, then it is worth looking at this issue in that global context. You know, I am struck by this, that whatever test we use to decide whether the Act is a success or failure, we have to be careful that one country's good endeavor may lead to another country's bad experience. There is a great moment when you can feel self-satisfied only to discover that you've exported the problem to another poorer country, less able and less willing to cooperate. That would be an unbelievable and bad outcome from our good endeavors. It would be a perversion of what we try. My conclusions are these, and I make them rather timidly because the Act is new. I'm not sure what knowingly or knows or ought to know means in the legislation of the criminal offences. I think it'll be interesting to find how our courts interpret these two sections and whether human trafficking as defined in the Act and slavery and servitude and forced and compulsory labour will deliver all that is expected. But let me say this. Do not judge this Act on the number of criminal prosecutions that are successful. I think that would be a big mistake. Judge it on the extent to which it can change through the targeting of the kind of prosecution that encourages our society to take responsibility for what has occurred. It is the public message that comes from us 800 years ago from the Magna Carta. The Magna Carta did very little. It achieved almost nothing in terms of its technical exposition of rules and regulations. But in the mind of the public, in the mind of the judges, and in the 19th century world of idealism, it fitted perfectly. It provided us with the spirit of the law, which the Holy Father mentioned this morning, this notion of bringing together in the Beatitudes this lovely idea of representing humankind, of dignity and of equality. I do not think that were we to leave the European Union, or indeed renegotiate the European Convention on Human Rights, that any of that should stop us in our endeavors. You know why? Because I think we have reached a stage where in our common law system we have incorporated many of these ideas. This is the last point. And many of these ideas have become entrenched in the culture of how our judiciary thinks and how we behave in terms of what it is we do. Just let me make this point. In 1998, we passed the Human Rights Act. It did not come into operation for 2 years. And I know that many of my colleagues throughout the legal world and the police and so on, magistrates, every aspect, we embarked on an enormous education program explaining what rights meant, that it was not just the letter of the law or indeed its spirit, but how we would act in the future. We would act in conformity with the compatibility of the act by behaving differently, by preempting legality, by social justice and understanding. And you know, that worked. It changed our thinking. That is not going to happen. That's not going to be reversed. So the Modern Slavery Act is an important legislation. For all we know, it may be the Magna Carta of its time, because it does something tremendous. It produces a vocabulary of change, an institutional independence given to the commissioner, and we are lucky to have such a man of distinction, of quality of judgment, and of integrity. Those are words that are difficult to say in the context of many professions today. And yet, he is one of these. Let us now be empowered by the words and wisdom of the Holy Father, by the bravery that many of us have to confront of disappointment. And remember, we are addressing the vulnerable, and it is true that the criminal law has a part to play, but I do believe that the economic regulation of the problem is within our grasp. Let us not lose this moment, even though it's Saturday, late in the afternoon, and I'm not a very good speaker, but there it is. You had the best this morning. I'm afraid you've left it to me at the end. Anyway, I commend the act to you.